Well, good afternoon. I think it's about 1 o'clock, and my name is Carl Habekost. I'm an attorney with some specializations in safety. We are also going to have Donald Elswick, a certified safety professional, on this program. Thank you so much for taking your time and making the effort to attend this third or fourth webinar series on OSHA for 2016. This webinar series, we're going to focus in 30 minutes on the new OSHA recording rule. It is a far-reaching rule that has impact not only in your workplace, but also in the sense that it provides OSHA with enforcement mechanisms that it didn't have before. In other words, OSHA now has opportunity to issue citations in areas that heretofore it did not have. This rule addresses several different issues, and we're going to talk about them. Electronic reporting of injuries and illness data. This data is going to be published for each individual employer on a public website. We're going to talk about employee access to injury and illness records, anti-retaliation regulations, commentary from OSHA about post-accident drug testing, and also safety incentive programs. We're in the middle of the weeds when we go through this. Keep in mind that the point of OSHA developing this new recording rule is to improve the tracking by OSHA of workplace injuries and illnesses. So let's talk a little bit about the history. I'm going to go back since I have a law degree and I question anything the government does. I want to know why and how they're doing it, what authority they have. OSHA was created in 1971. It had a statutory directive to make sure that workplaces were safe, that there were safe work conditions, and to preserve our human resources. I did some investigation. OSHA definitely has legal authority to require electronic reporting of injury and illness data, and that has not been disputed by any employer groups, although they were not happy about it. Section 8C2 of the Act directs OSHA to require employers to maintain accurate injury and illness records. There's also an empowering section in 8G2 that grants authority to OSHA to prescribe rules and regulations as necessary to carry out responsibilities under the Act. Now, this particular rule has been around, as I indicated, since 1971. There has been a few modifications until recently. In 1971 was the beginning of the requirement for employers to record work-related injuries and illnesses. In 1994, OSHA added the requirement of reporting to OSHA fatalities and then multiple hospitalizations. Nothing until 2001 when OSHA published forms. You're all familiar with those forms, the 300, 301, and 300A forms. So those began in 2001. In 2014, OSHA amended the rule to require more extensive reporting to OSHA of work-related incidents, including not only fatalities, but even one hospitalization, amputations, loss of an eye. We've already had a webinar series on this. It resulted in the rapid response investigations. OSHA has had significant input from employers as a result of this rule. Well, right about that time, OSHA issued a proposed rule, and that's what we're talking about today, the record-keeping rule. There were public meetings on January 9th and January 10th of 2014 concerning the electronic reporting of injury and illness data. OSHA was very clear they were going to put this data per employer onto a public website. There was concern raised in testimony and discussion during the public meetings about underreporting by employers because they didn't want to be seen as having excessive injuries. So in August of 2014, there was a supplemental notice in a public comment period about amendment for anti-retaliation provisions. Now, you've probably heard a lot of chatter, seen something on the internet. Most of it has to do with this anti-retaliation provision that OSHA put into the recording rule. And it also affected post-accident drug screening and some other issues. So, the final rule was published on May 12th, 2016. It was supposed to be effective August 10th, 2016. The electronic reporting aspect remains effective as of August 10th, 2016. However, due to employer lawsuits for temporary injunctions against the anti-retaliation provisions of this rule, those aspects have been postponed to November 1st, 2016. Now, the amendment to the recording rule requires employers to submit injury and illness data electronically to OSHA, as we talked about. Requires employers to inform employees of their right to report injuries free from retaliation by the employer. Requires employers to establish an injury reporting method that will not discourage employees from reporting. Prohibits employers from retaliating against employees for reporting injuries. And then, in the comment, as we discussed, OSHA talked about how automatic post-injury drug testing deters the reporting of injuries and violates the rule. So I believe Don Elswick is on the line. Don, would you like to join us and bring your expertise to the table here about recording and whatever else you want to talk about today? You there?
Sounds great, Carl. So let's go ahead and go forward with this. Carl did a great job of outlining the 2016, kind of the 5 most important things we picked up on. One of the things we wanted to recognize, and we understand that employers have the question, well, what does this mean to me? Well, again, OSHA, in their infinite wisdom, and as I always say to make it clear, has determined that certain size companies, whether you're small, medium, or large, and you can tell we tried to outline exactly what those requirements are. One of the things that we look at there, if I can get settled on the slide, is that the annual submission is only required with employers greater than 20 employees. And then as you go down for 250 plus, you'll go through. The year 1, just so you know, only an OSHA Form 300 is due on July 1st, 2017. And then the year 2 deadline is 2018. And annual deadline will then turn around and be March the 2nd. So that was kind of the summary for the electronic, and I just wanted you to see the phased-in process down below there. Again, as we discussed, the 300-day deadline and the each deadline there following. Some of the exceptions, and I get asked about this a lot. Again, I know as a safety professional, we want to balance confidentiality, but we also have a obligation and even the ethics to go ahead and protect employee privacy. So as you're looking at that, one of the things that I always look at on this is, what are those exceptions? Well, here's what we want to protect. We want to protect the employee's name and address. We want to protect the physician's name and address, and also the treating facility. And I make it very simple. We can go to some of the Health Insurance Portability Act and different HIPAA laws, or we can just say, what would we want to do in our own circumstances? So that usually works well going through that. The other thing that we've been questioned about is, what am I going to do once I start posting and this access to the data? What's going to be included? Because again, as the leads for safety, health, in many cases at your plant, you're going to be asked by your leaders, what are we going to have to report? And there's been a lot of misconceptions. So we wanted to hit the four areas. You will have to have an establishment-specific injury and illness data, so that'll be out there. The next thing that you're going to pick up on is this will be posted to OSHA website with public access. For many people that have been able to go through an OSHA inspection, this will be nothing new. It's going to be the same type format that's now used for the OSHA inspection. OSHA, again, part of their preamble, they think that they'll nudge employers to abate hazards. And many of us have seen what gets tracked is what gets repaired, or in other words, what employers notice out there. So while there may be areas and companies that are well beyond this, some companies, this may actually say, okay, look, I don't want the public embarrassment. I want to protect the image of my company, and I'll go through that. And the last thing, again, and we all know this, public disclosure is a powerful tool in behavioral modification. A lot of us are familiar with some of the Skinner research from our early academic days in psychology, and that's kind of what they're going back to. Again, most employers are going to be far in advance in front of this, but just wanted to kind of give you their logic if you're asked about that. So let's talk about some of the recording criteria. Once again, people ask this also, are we changing the rules? The great thing about it, no, we're not changing the rules. And the last thing, it didn't change your obligation to retain the records. The 5 years you must retain those records. So with that recording criteria, the only thing that changed is, guess what? Where a lot of us followed it up after the fact with the Department of Labor reporting, now we'll actually be doing it more in what I'll call a real-time fashion. So one of the things that we wanted to do after we kind of talked about the 2016 changes is talk a little bit about what Carl and I get many questions on, and that is workers' comp versus OSHA criteria. It's one of the greatest areas that we get into where people start confusing workers' comp and OSHA. And I caution people, they are not the same, and we tried to give a chart here to describe it. The first, what is the OSHA recording criteria? Well, it must be work-related. It has to be a new case. In other words, if it's a re-aggravation of a prior recorded injury, you don't have to do it. And then they give what I'll call some general outcomes from injuries. Obviously, most serious death, and then we go down days away, restricted work, any treatment beyond the first aid that's listed in the guidelines, loss of conscience, or significantly injury that's been diagnosed. So that's your OSHA criteria. Workers' comp is sometimes more broadly established. I know people understand that, but again, recognizing these are two separate programs will create not only in ourselves a better understanding, but also our managers. So workers' comp criteria in the course of and arising out of employment, and again, you must establish a causal relationship due to the preponderance of evidence. So we obviously want to look at that. I know Carl and I both have been called on. There's going to be an area after the seminar. If you have cases you're curious about, feel free, to send those along or ask questions on that. But it's a very confusing area for a lot of experienced employees. So with that said, let's go back to OSHA. And we tried to give a chart here, and we're going to go through this very quickly. When do you record? Because this is the question, again, you're going to be asked. And the first question, did the employee experience an injury or illness? Well, if they don't, guess what? Don't record it. Is the injury work-related? Again, if the answer is no, you won't record. If the answer is yes to both of those questions, is it a new injury, or is it a case that you previously recorded that was re-aggravated or go through? If the answer is no, then you update the previous injury. If the answer is yes, guess what? We have a new illness and injury. Then you must apply the general recording criteria. If it does not meet those, or if there's a letter of interpretation that says, look, we do not want you to record this, then you won't. And the last step on that, if the answer is yes, you will record the illness. So we're going to give a couple of scenarios. We find this very useful in our learning, and Carl and I have used these, and we love them because this is some of the things that we go through. So you have an employee report to work. Several hours later, the employee goes for a smoke break. The employee slips on the ice and injures his back. Since the employee was not performing a task related to the employee's work, the company has deemed this incident non-related and therefore not recordable. Well, again, as you look at this, an injury or illness is not work-related if it's solely the result of an employee doing personal tasks, unrelated to their employment. Well, we think, okay, smoking's not part of that, and it also has to include the secondary part of that, at the establishment outside assigned working hours. Well, as we all know, usually smoke breaks are in there. In order for this case exception that is listed in 1904-5 B2V, basically it would have had to, both of the exceptions. It must be doing a personal task outside of working hours. Again, the letter of interpretation, and many of you are familiar from January 15, 2004, this is a recordable injury, and it would need to be recorded as a case. So just a great example, because you'll get that all the time. The next one, and we did start out, this is not work-related. An employee drives onto the company parking lot at 7:30. As he exits his car and proceeds to the parking lot, a second employee approaches him. They get into a physical altercation. The first employee breaks an arm during the altercation. The employee goes to the doctor, receives medical treatment for his injury. They deem it's not work-related, as we said, and not recordable, since the employee had not reported to work. Well, once again, this is that case where, and I often have heard this makes no sense. This case actually is recordable. And in an opinion on this, and this again is out of that January 15, 2014 letter, they said again that it was unrelated, that a task had to be personal, which we hope that altercations are. But this exception did not apply here because the injury and illness, even though he had not clocked in, was within working hours. So once again, the agency ruled this case is work-related. I know as a safety professional and also as an attorney, this one absolutely drives employers mad. And one of the things we'll look at, and Carl can talk about this, is with workers' comp. There are some exceptions to that, which again infuriates other employees. So the last one we want to look at, and this is the scenario we want to go through, is a medical treatment beyond first aid. So a worker, again, has experienced wrist pain after spending most of his day at a computer. He goes to the OCHealth clinic, but before he gets to the clinic, he buys a rigid wrist brace. And as all of you know, that is beyond first aid. He goes to the clinic. The doctor says, hey, if it's giving you relief, keep wearing it. Does this constitute medical treatment? Well, again, and this was set up in those 7 examples in the January 15, 2004. This is a recordable case. So again, we've tried to give you some examples there of what the cases are. We also tried to go through and talk about some of the exceptions, but again, this is just several examples. We do not need to be all-inclusive. So with that, Carl, I'm going to turn it over and let you take us home with the rest of it.
Thank you very much, Commander Elswick, or retired Commander Elswick. I would note that this sort of webinar could actually go 90 minutes without any problems whatsoever. We're squeezing this into 30 minutes. So we are by necessity having to go through some very detailed data and information very quickly. This next slide we entitled Employee Involvement in Injury Reporting. This is where the employer under this new rule is required to inform each employee of how to report a work-related injury. Now, for those of you in the know, you already realize that the prior rule had required employers to set up a way for employees to report injuries and illnesses. But this new rule adds text to clarify that the reporting procedure must be reasonable. It must not discourage or deter reporting. I think the easiest and simplest example is some employers have multiple people that an injured employee must report to. So that would discourage reporting. There could be perhaps a fear of the employees that they would have some sort of discipline if they reported an injury. So that would deter or discourage reporting. All right, now this new rule also mandates that the employers must inform employees of their right to report injuries and illness. This is an employer mandate. So I would note at this point that no matter what you do in training, you must document it in writing. If it's not documented in writing, it didn't happen. I don't care what you say. You're dealing with a government agency, and it doesn't just have to be OSHA. It can be the Bureau of Workers' Compensation, the Ohio Department of Job and Family Services, the Ohio Civil Rights Commission, whatever agency, you have to have documentation. So whenever you do training in informing the employees of this policy, you must document it, have it in writing. This slide shows that you must advise them that the employer is prohibited from discharging or discriminating against employees for reporting work-related injuries and illnesses. You must not discharge or discriminate against any employee for reporting a work-related injury or illness. I'm going to ask a question right now for you to think about. We won't have time to answer it today necessarily. We can discuss it a little bit later. What about your policy for immediately reporting injuries? After all, you want to have a safe workplace. If there's a hazard out there, somebody gets injured, you want to know about it immediately, right? Well, the comments in this rule, OSHA has indicated that if you have an immediate reporting of an injury requirement, you have to use some common sense. They use an example. There's a wear and tear injury. Somebody develops a shoulder strain over time. Initially, it didn't appear serious enough to result in an injury that they needed to report, but over time, they developed a shoulder strain. So there was no single incident. In some of these public meetings that I talked about early in our webinar, the concern was that employers were disciplining people for not immediately reporting an injury when it didn't happen immediately. So although it seems kind of crazy as an example, I believe that's what OSHA is really talking about. Your policy should allow for reporting within a reasonable time after the employee realizes they've suffered a work-related injury. There are some changes as far as access to records that I just want you to be aware of. Already the rule requires that you have to provide access to records if an employee or their representative requests it. This rule expands on that, and they identify a, quote, personal representative of an employee or former employee. So an authorized representative is usually a union representative pursuant to a labor management contract, but a personal representative can be any person the employee or the former employee designates in writing. It can also be the legal representative of a deceased or an incapacitated employee or former employee. So that's who has access to the records. When do you have to give it to them? It differs. All OSHA 300 logs must be presented to whoever asked for it under the guidelines I just mentioned by the end of the next business day. Interesting, OSHA 301 incident reports, an authorized representative pursuant to a labor management contract does not need to be provided this information until 7 calendar days. However, personal representatives must be provided this information by the end of the next business day. Can you charge for this? No, not the first time. Second time for the same information, you can charge a reasonable fee. While some unexpected concerns popped up, as we indicated early on, OSHA's primary concern in expanding on this recording and reporting rule was to ensure the completeness and accuracy of injury and illness data that are collected by employers and reported to OSHA. So they had the electronic reporting aspect of this rule, and that was what most employers were talking about and most safety consultants were talking about. All of a sudden, different issues came up as people began to review and read the preamble to the rule and some of the commentary provided by OSHA. For example, safety incentive programs. OSHA commented that most safety incentive programs which reward employees for not having any recordable injuries or not having any lost time probably violate this rule. Why, you might ask? Well, because employees don't want to report injuries if they are going to cause their coworkers to not receive a bonus or some other award for not having lost time injuries or not having recordable injuries. We suggest that if you're going to have safety incentive programs, it encourage employees to participate in safety committee meetings, reporting near misses, that sort of thing. I believe that safety incentive programs are going to be a problem under this new rule, and I believe Don feels the same way. What about policies that discipline employees for failing to timely report an injury? Well, we already talked about that. That could violate the rule. Interestingly, this new anti-retaliation language that we spoke about permits OSHA to issue citations now, even if the employee has not filed a complaint. Heretofore, an employee had to file a complaint with OSHA within 30 days of the incident. Then OSHA would investigate retaliation under Section 11C of the Act. Now, under this new provision, OSHA on its own can begin to investigate and issue a citation. And remember now, OSHA also has increased fines by 78%, so it's going to become more costly to violate the rules. Now we're going to move fairly quickly. We've talked about OSHA and post-accident drug testing. Why in the world would you think post-accident drug testing would violate this rule? Well, OSHA has several comments about that. Most interestingly, they believe that this discourages people from reporting injuries if they have to go through post-accident drug tests, especially if it has absolutely nothing to do with impairment. Don Elswick might want to chime in here because in his position, not only currently where he's at, but in his other prior positions, he has worked in Europe and in Canada, and those other countries have a view contrary to what we do here in Ohio. Don, do you have anything to add on this?
Yeah, go ahead and comment on this. For a lot of employers that are very nervous about this testing, Carl really gave good advice. Number one, have your programs documented. Also, anytime employee safety is at risk, you can usually justify it. And the last thing, and we know this is a mature safety program, create a relationship with your providers. knowing the mechanism of injury and also understanding how that injury occurred and not being able sometimes to explain it will lead you into it. There's one of the clients I deal with in Canada has a very rigid position on substance abuse training, and then in Europe and South America, it's totally culturally different. But I will tell you one constant: do not have a pro forma, I'm going to test everyone, and have a good policy. So thank you, Carl. That is exactly the way it needs to be approached.
All right, thanks. This screen shows some examples of when OSHA believes post-accident drug testing probably would violate this rule. A bee sting injury. What does that have to do with being intoxicated or impaired by narcotics? Perhaps an obvious malfunction of a machine caused an injury. What does that have to do with impairment? So those are just some examples OSHA has used and kind of tags on what Don just talked about. OSHA believes that automatic post-accident drug testing deters reporting, as I just talked about. You don't have to, as an employer, suspect that there's impairment. In fact, you can't even prove it. That's a medical issue, usually opined by a physician. But it has to be the sort of situation where drug use might be a contributing factor to the injury. Well, let's talk about this. Drug testing, OSHA, and workers' comp, because I can see in my mind some people out there I know who are attendees vibrating in their seats right now because they participate in a drug-free workplace program in order to receive discounts on their premiums. While OSHA has indicated very clearly in the rule, in the commentary to the rule, that if drug testing is performed to comply with the requirements of a state or federal law or regulation, then it's not deemed to be retaliatory, and the final rule does not prohibit such testing. Then OSHA goes on to cite Section 4B4 of the OSHA Act, which prohibits OSHA from suspending or affecting workers' compensation laws. But that really begs the question, doesn't it? The program in Ohio is a voluntary participation in drug-free programs. Voluntary. You get discounts on your premiums if you're a state fund employer. Is that covered by OSHA's statement that if you're required to participate in a drug-free program through a workers' compensation law? I don't know. And if anybody out there is giving you a solid answer on that, they're a false prophet. I don't think anybody really knows at this point. Part of the reason, therefore, that this aspect of the rule has been postponed to November 1st to sort of flesh out some of these problems. Finally, I want to touch base in 30 seconds, about Ohio's new medical marijuana law that will become effective soon. It's going to take a lot of time yet before we even see this being applied in our state. But Ohio's new medical marijuana law and drug testing programs, other states, and I know we have attendees from Michigan and Indiana and Colorado. Clearly, Michigan and Colorado have dealt with this. Because marijuana is illegal from a federal perspective, it's still a Schedule I drug. Employers can operate their workplace drug-free, treat it just like you do any other drug. And I really have no other comment on that. Our firm is going to talk more about the new medical marijuana law at our employment law seminar coming up in October. If you have any questions, as Don talked about, after this webinar, you have our contact information. Please feel free to email or call either Don or myself. We'll be glad to answer your questions to the best of our ability. As I indicated, this is really quite a far-reaching rule that impacts employers, not only how they operate their workplace, in their procedures, in their rules, but also provides enforcement mechanisms for OSHA that could cost employers more money in citations. Well, thank you very much for your time. We really appreciate you attending this webinar, and we will have other OSHA webinars in the near future. Thank you.